In property transactions, people often say, if the Bayaana is gone, the money is gone. But legally, that statement is not always correct. The Supreme Court and the Bombay High Court have repeatedly clarified that forfeiture of money is never automatic merely because a contract uses the words token, Bayaana, or earnest money. If the legal position is misunderstood, a party may either lose lakhs unnecessarily or recover amounts that were wrongly forfeited. Introduction. Friends, welcome to my YouTube channel Legal Information Law Insights. I am Advocate Mukund Mahajan. I am pleased to share that our channel has crossed 1 lakh subscribers and received the YouTube Silver Creator Award. You may also support the channel by becoming a member with a contribution of 59 rupees or 119 rupees via the GPay QR code shown on your screen. Thank you for your continued trust and support. Now, let us move to today's topic and understand the correct legal position in Indian law. Basic legal understanding. In property transactions, the classification of money as token money, earnest money, Bayaana, or advance money is not merely a matter of terminology. Its legal nature determines whether the amount can be forfeited, whether it must be refunded, and whether the court will treat the forfeiture clause as valid or penal. Courts generally examine 4 important factors: the terms of the agreement, the nature and purpose of the payment, the conduct of the parties, and most importantly, Section 74 of the Indian Contract Act, 1872. Under Section 74, even where a contract contains a forfeiture clause, the court will allow only reasonable compensation and not an arbitrary penalty. Token money, initial intent payment. Token money is usually a small amount paid at the initial stage to show seriousness and secure negotiations between the parties. In many cases, token money is paid before execution of a detailed agreement to sell. Its legal treatment depends entirely upon the wording of the document, existence of a forfeiture clause, and the intention of the parties. Where there is no clear contractual clause permitting forfeiture, courts generally lean in favor of refund, particularly where the transaction fails without deliberate default by the purchaser. This principle is broadly consistent with the reasoning adopted by the Bombay High Court in Jyoti v. Sindhubai Ramraoji Shende. Bench, Justice A.S. Chandurkar. Principle: forfeiture requires a clear contractual basis and cannot be presumed automatically. Thus, merely calling an amount token money does not automatically permit its forfeiture. Earnest money Bayaana, security for performance. Earnest money, commonly called Bayaana, is legally recognized as a deposit given as security for performance of the contract. It is usually paid under a written agreement to sell. However, even earnest money is not automatically forfeitable. The law on this issue has been settled by the Supreme Court through several landmark judgments. Supreme Court Position. Fateh Chand v. Balkishan Das. Reported in AIR 1963 SC 1405. The Supreme Court held that forfeiture is subject to Section 74 of the Indian Contract Act. Even if a contract allows forfeiture, the party retaining the money cannot claim an amount that operates as a penalty. Only reasonable compensation can be retained. Mola Bucks v. Union of India. Reported in AIR 1970 SC 1955. The court held that where actual loss is not proved, forfeiture may not be justified beyond reasonable limits. The judgment emphasized that Section 74 controls forfeiture clauses. Kailash Nath Associates v. DDA. Reported in 2015 4 SCC 136. This is one of the most important modern judgments on forfeiture law. The Supreme Court clarified: forfeiture is not automatic. Section 74 applies even where the contract expressly permits forfeiture. Compensation must be reasonable. And where no loss is proved, retention of money may not be permissible. This judgment substantially clarified the law relating to earnest money and contractual penalties. Bombay High Court Position. M.S. Abhay Construction v. State of Maharashtra. Bench, Justice S.V. Gangapurwala. The court observed that where the purchaser is not at fault, forfeiture cannot be justified merely because the contract contains a forfeiture clause. Ghulam Ali Ismail Khan v. Sheikh Kalimullah. Bench, Justice R.G. Avachat. The court reiterated that forfeiture depends upon the terms of the contract, readiness and willingness of parties, and the nature of breach. Correct legal position on earnest money. Earnest money may be forfeited only when the contract clearly permits forfeiture, the purchaser is actually in breach, and the amount retained is reasonable and not punal. Therefore, even Bayaana is not automatically lost in every failed property transaction. Advance money, part payment of sale consideration. Advance money is generally treated as part payment of the sale consideration. Unlike earnest money, it is not necessarily intended as security for performance. Therefore, courts are usually more cautious before permitting its forfeiture. As a general rule, advance money is refundable unless the agreement specifically authorizes forfeiture, and such forfeiture satisfies the test of reasonableness under Section 74. This principle is reinforced by the Supreme Court judgment in Kailash Nath Associates v. DDA. Bombay High Court trend on advance payments. The Bombay High Court has repeatedly held that part payments cannot be arbitrarily forfeited. The seller must justify retention strictly under the contract, the facts of breach, and Section 74 of the Indian Contract Act. FC Neeta Sawant v. State of Maharashtra. Division Bench. The court indicated that amounts not clearly established as earnest money cannot automatically be forfeited merely because the transaction failed. Very important clarification. A common misconception is only earnest money can be forfeited. That statement is legally incorrect. The correct legal position is even earnest money is not automatically forfeitable. Even advance money may sometimes be forfeited, but only under strict legal conditions. Ultimately, the court examines the contract, the nature of payment, who committed breach, and whether the forfeiture is reasonable under Section 74. Core legal principle. The entire law on forfeiture revolves around Section 74 of the Indian Contract Act, 1872. The key principle is a forfeiture clause does not create an automatic right to retain money. Courts grant only reasonable compensation. No party can impose penalty or obtain unjust enrichment through contractual wording. This principle applies to token money, earnest money, and advance money alike. Practical legal advice, litigation perspective. From a drafting and litigation perspective, parties should clearly define the nature of payment. Expressly mention whether the amount is token, earnest, or advance. Draft precise forfeiture clauses. Avoid vague language like, amount paid shall stand forfeited. Conduct proper title due diligence before payment. Record all payments through banking channels. And include detailed default and remedy clauses. Because in property litigation, drafting often decides the outcome. Common mistake in property deals. The biggest practical mistake is that parties loosely describe every payment as Bayaana and assume it can automatically be forfeited. However, under Indian law, token money, earnest money, and advance money all carry different legal consequences. Courts always examine what is written in the agreement, the actual intention behind payment, which party committed breach, and whether forfeiture is legally justified under Section 74. Closing. So, in property law, the real issue is not merely how much money is paid. The real issue is how that payment is legally structured. Because that legal structure ultimately determines whether the amount is protected or forfeited. Thanks for watching this video. If you found it informative, please like, freely subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.